We begin with this, former President Trump making his first formal legal challenge to the FBI's search of his home at Mar-a-Lago. Chief election and campaign correspondent Robert Costa is following this story for us from Palm Beach, Florida.
Good morning. The former president's 21-page motion is not just a legal move, but a political argument. It claims Trump is the frontrunner for the Republican nomination in 2024 and casts the investigation in political terms. The Justice Department's response: this is not political. 2 weeks after the FBI search of his Mar-a-Lago home, former President Trump is asking a federal court in Florida to stop federal investigators from reviewing the documents taken until a special master or a third-party attorney can be appointed. In the legal filing, he also requests that the FBI return any documents that went beyond the scope of the search warrant.
A special master would be almost like an extra judge to take an independent look at those.
The filing also reads as a political pitch ahead of a possible run in 2024, in which Trump's lawyers make unsubstantiated claims of investigators being partisan, saying law enforcement cannot be used as a weapon for political purposes, and go on to say that the matter at hand involves not only the constitutional rights of President Trump, but also the preservation of executive privilege. National security lawyer Bradley Moss.
And by admitting this is really all just about executive privilege, Donald Trump is admitting these are official records, not personal records. This filing was all about trying to shore up his position with the Republican base and hoping that no one notices it's not properly constructed. Is going to get slammed by the judge.
So far, a U.S. official tells CBS News that the Justice Department has retrieved at least 150 classified documents from the boxes Trump handed over to the National Archives earlier this year. And the New York Times reports that since federal agents re-engaged with Trump's legal team this summer and then searched his home, that number has climbed, with more than 300 documents with classified markings obtained by the Justice Department.
I personally approved the decision to seek a search warrant in this matter.
The Justice Department released this statement after the motion was filed Monday, saying the search was authorized by a federal court upon the required finding of probable cause, while the former president continued to rail against the search he called a break-in.
All he knows is to throw things at the wall and to try to file various motions or lawsuits to try to delay things. It's worked for him in the past. What the problem he's got here is it's a criminal investigation. A grand jury has been convened. Federal prosecutors already had to get a search warrant for his property. That's something he's never faced before.
This all comes as a Florida federal judge prepares to decide this week whether to release a redacted version of the affidavit that led to the FBI search of the Mar-a-Lago estate. That affidavit could reveal more about why FBI agents went in and why they believe a crime might have been committed. Anne-Marie, Errol.
All right, Robert, thank you. I want to bring in CBS News legal contributor Keir Dougall to give us some analysis of this filing so far. So, Keir, for a lot of us, I think this is the first time we've ever heard of a special master before. So I want you to sort of break down, like, what a special master is, who would do this, and also whether the role of a special master is always the same, or can it be sort of redefined? Because I find it interesting that the president's team is asking that the special master look at the documents before the FBI does.
Right. Well, that's comes a little bit late. The government's already looked at the documents, and we're now 2 weeks in post-search. Presumably, the government's been looking at these documents for the entire time. So that's a little bit late. But the last time that we may have focused on the role of a special master would have been during the search of the law office of Michael Cohen. You remember him? He was President Trump's personal lawyer and fixer, and his offices were searched. A special master was appointed then to review the documents, basically to sort out which documents are privileged and are not. So we have the same question here, potentially. And a special master is effectively an assistant to the court, someone qualified to make legal determinations like this, but effectively someone who is capable of taking on a big job for the court and taking it off the court's plate. The role of a special master in any given case is pretty fact-specific, depends on what the court needs and the authorization or the order appointing a special master can be tailored to fit those special needs. But basically, a special master is someone who comes on to assist the court.
And Keir, what about this argument of executive privilege? The Supreme Court already ruled against President Trump earlier this year when he tried to use that privilege to keep documents from being turned over to the January 6th committee. Throughout American history, executive privilege seems to have represented sitting presidents. It's a power for sitting presidents. It does have limits. So what do you make of that argument here?
Right. So that discussion around the January 6th committee request for documents relating to former President Trump is informative and helpful, but I'm not sure that it's going to answer all of the questions here, because we're talking about a different set of issues and a different set of documents. But, you know, the basic rules of the road are that the president gets to have some zone of communication on important matters, particularly national security, things relating to law enforcement, foreign policy, and sometimes just the internal deliberations. There's a zone of protection around that. But particularly for things that are deliberative processes, that's not a sort of a bulletproof shield. If there are higher needs, for instance, of a grand jury or in a criminal case, the president's needs can yield. That's the teaching of the issues relating to former President Nixon. So what we saw, though, in earlier this year with the January 6th hearing was something we hadn't seen in our history before, where a former president was asserting a privilege. And it was being rejected by a current president. So I think the rules here are the way they're likely to shake out is that the current president needs to be taken very seriously if there's a decision that material should not be considered a matter of executive privilege, but that a former president ought to at least have the ability to weigh in, ultimately to be decided by the courts. Earlier this year, the courts basically said that President Trump hadn't shown enough to change President Biden's determination that the January 6 materials were important to that inquiry about the worst attack on our Capitol since the English in the early 1800s.
You heard in Robert's report that the first page of Trump's motion claims that he is, in fact, the front runner in the 2024 election. Should he decide to run, of course, because he actually has not said that he was running. But let's not get bogged down with the details here, right? Should he run? How would that change things in terms of the investigation? Because then, yeah, you would be talking about a presidential hopeful.
Right. So, you know, one of the things that is terribly important to our rule of law and our democratic traditions in the country is this notion that prosecutions, if one occurs, and we're not even sure that a prosecution will follow from this search warrant, that's very important to note, but that if one occurs, that it's not motivated for political reasons. And so, you know, by continuing to front the idea that the former president might be the front runner a couple of years hence, it is asking the public, I think, to consider that this is not a search warrant, or to take the focus away from the fact that this search warrant was approved by a federal court upon a sworn statement of an FBI agent that demonstrated probable cause that a crime was committed. So you have that extremely robust procedure, all of those safeguards that are in place and were approved by the independent third branch of our government, the judiciary, prior to this search, on the one hand, versus a claim that this is politically motivated on the other hand. And right now, the question before the judge reviewing the request to release the search warrant affidavit, I think, is going to focus on those issues. You know, is there something that can be released from that search warrant to perhaps appease any concerns on this in this area, or are we going to have to wait through the process and let these things develop and be patient?
Keir Dougall, thank you very much.
Thank you, Keir.
Thank you.